Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Malkin Fund, the Commonwealth Fund, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, and from the corporate community, Mutual of America. I'm Richard Heffner, your host on The Open Mind, and this is the second of a series of 2 programs with Linda Greenhouse, the brilliant New York Times writer whose consistently illuminating coverage of the United States Supreme Court brought her the 1998 Pulitzer Prize, and whose distinguished reporting from the High Court over the past generation has helped us understand better what she recently referred to as competing visions of the Constitution and the role of the Supreme Court. Visions she characterizes as maximalist and minimalists, and identifies respectively with Mr. Justice Scalia and Mr. Justice Breyer. Thank you for staying. There are so many questions relating to the High Court that I've wanted to ask you about. One of them having to do with the what you consider the impact of the presence now, and you knew the court before there was such a presence, of 2 women, actually, on this male-dominated, previously male-dominated court.
Well, it's probably still male-dominated, but, you know, it's always hard to tease out their impact as women as opposed to their impact as, you know, very smart, serious players on the court. And certainly Sandra OConnor's had a major impact on the court.
Philosophically?
Yes, because she is very much a case-by-case judge. You have to make the case to her every time, and you cannot take her vote in most types of cases for granted. So a lot of cases come down to, you know, what will Justice OConnor say? I think that accounts for a fair amount of an aspect of the court's work that we didn't have a chance to talk about in the previous program, but the setting of the court's agenda, the court's setting of its own agenda, rather. I think I mentioned that the court, I'm not ducking your question, but it's just a segue. The court takes only about 80 out of 8,000 cases, so which cases does it take? There are obviously a number of issues that the court has had in front of it, and they've chosen not to get engaged. I mean, one of them is affirmative action. It's been 24 years since the court last looked at affirmative action in higher education, the Bakke case.
Isn't it about to do so now?
Well, we'll see. They've been asked to. Whether they do it or not, we don't know yet in the Michigan case. But anyway, a lot of people think that the reason the court has sort of ducked this issue is that there are 4 justices who feel strongly that affirmative action has no place in higher education. There are 4 justices who feel quite strongly that it does. And there's Justice OConnor, and neither side knows exactly how she would vote. And so neither side has voted to grant such a case. This is speculation. I mean, I don't know this, but this is the kind of received wisdom. Neither side has been willing to grant such a case because why run it off the flagpole if nobody's going to salute and you might come out with the wrong answer? So I think her approach and her presence has had a measurable impact on the shaping of the court's docket over the years. Justice Ginsburg is a very, very smart lawyer who came to the court with probably more relevant experience than almost anybody. She argued, I forget the number, but somewhere between 7 and 10 cases before the court as a public interest attorney arguing for women's rights, and really you know, brought the court into the modern constitutional era of women's rights. And she's also an expert in federal court jurisdiction, civil procedure, and so on. They give her a lot of the kind of tough, not the sexy necessarily, but like the lawyer's lawyer type of cases to write the opinions in. So she's obviously had an impact as well.
Well, going back to the matter of 4 and 4 and one person in the middle, is there any other justice, sitting justice now, who is as questionable about where he would come down? Because I gather it would be he.
Well, you know, Justice Stevens is very much a free thinker. I mean, he's, I think, comes to every case with a lot of questions, and he's probably the most frequent. If there's ever a lone dissent, you know, an 8-to-1, these days the one is rather likely to be Justice Stevens. He sees things his own way. You know, in the old days, before William Rehnquist became Chief Justice, he was an Associate Justice for 15 years. He was always the lone dissenter. He was always the outlier back in the day, as my daughter would say. And now he, of course, speaks for a majority most of the time. So it's, you know, partly a function of the individual, also partly a function of where the spectrum of opinion is on the court at any given time.
Well, you know, we were talking last time, and you were writing in your piece in the Times about the competing visions of the role of the court, about the surfacing of Justice Breyer as a particularly articulate spokesperson for a position that Scalia is a particularly articulate spokesperson for the opposite.
Mm-hmm,
I think my tense is all mixed up there.
I got you.
But, you know, I wondered whether Justice Breyer was moved into that position. You may think this is way out. By the fact that he participated in the unanimous decision by the court during the Clinton administration that the conduct of the presidency wouldn't be affected by a lawsuit against a sitting president. And that goes so much against the way you describe his position now, thinking about consequences.
Yeah, well, no, that's a good question. And actually, it was 9-0, but Breyer wrote a separate opinion. He obviously was not real comfortable with the majority, which was written by Justice Stevens.
But he voted.
He voted. But he, I can't quote exactly what he said, but his opinion was obviously coming from a position of discomfort. In fact, I remember running into him in the hall at the court a day or two after the opinion came down, and I was maybe feeling sort of cheeky, and I went up to him and I said, "I felt your pain." He just kind of, so I think he saw some of the problems you're talking about the Paula Jones case in Clinton against Jones, that the rest of the court seemed rather willfully blind to at the time. So no, I don't think it comes out of that. I think Justice Breyer had a very good term last year in the sense of writing a number of opinions and separate opinions that really did seem to spell out the guideposts he set for himself in a lecture that he gave just about a year ago, last fall, at NYU, the Madison lecture, where he, for the first time, kind of worked through his judicial philosophy and pulled a lot of stuff together and gave kind of an index of what's important to him as a judge, what we talked about last time, the context and the consequences. And I think having done that in a very systematic way for himself in preparing that lecture, it helped him fit the individual cases into some framework that was quite beneficial to him in terms of dealing with them during the term. So it was a kind of emergence of Stephen Breyer in a way that there hadn't been before, I think, this last year.
Do you think that if we developed, and we touched on this last time, something akin to an Official Secrets Act, I mean a whole series of things that derive from the same kind of thinking, the same philosophy, as represented by England's Official Secrets Act, do you think you could guess as to where and how the present court would take its or their stand?
Well, of course, again, context counts. I mean, but This is a highly speech-protective court. This is a very strong First Amendment court. In case after case, whether it's speech on the internet, the court has overturned a series of federal laws that have tried to keep the internet a pornography-free zone, at least with respect to children and so on. Last term, the court struck down the virtual child porn statute. The court's been protective of speech in all kinds of contexts, so that anything like, it doesn't have to be an act. I don't think we'll have obviously don't think we'll have an Official Secrets Act, but maybe the functional equivalent in terms of executive branch behavior comes to the court with the presumption of irregularity, I think. The court will scrutinize anything like that through a very strongly focused First Amendment lens. Now, when I said context counts, I mean, obviously the context in which something like this would come up is the current war on terror situation. And so in wartime, as we know, government behavior comes to the court with a presumption of entitlement to deference. And the court's history certainly reflects that as well. So we'd have a kind of clash of two instincts, defer to the political branches during wartime, and a real skepticism about official limits on free speech.
Well, when there is a clear and present danger, the court does tend to give some space to the government. Do you think then that in the free speech area there has been a failure on the part of legislators to indicate that there may well be a clear and present danger posed by what is called free speech, by media abuses, called that by others? Do you think that the present court, and you're saying that it's a very strong First Amendment court, is there any indication that anything will give, as we point out, clear and present dangers in anything other than war and peace?
Well, if I understand your question, I'm not sure that I do. But
pretty convoluted.
Yeah, it is. But, it's going to depend on how these cases come up. And I think in a lot of the public discourse, they seem to be presented as all or nothing. And they need not be all or nothing. For instance, there's a case now recently decided by the Sixth Circuit Court of Appeals on closing these deportation hearings, these so-called special interest deportation hearings, which the head immigration judge, acting at the behest of the Attorney General back in a year ago, announced that all these special interest hearings would be closed. Not only the hearings would be closed, that puts it too narrowly, that even there would be no public acknowledgement of the existence of these deportation proceedings, and it would just, fall into a black box. And obviously this was quite different and was challenged, and obviously the government said, we have national security needs, that's why we're doing this. Well, what the lower courts have said so far, the Supreme Court hasn't had occasion to weigh in on this yet, what they've said so far is it's not all or nothing, it's not that they're all closed, it's certainly not that they're all open. No judge is going to say, we're just going to ignore your national security claim and order these open in the name of the First Amendment. It's rather that there's a presumption of openness in our society to official proceedings, and the government has to make its case on a case-by-case basis why a particular hearing or proceeding should be closed. Now, the government's arguing that's not good enough, because then we would pick and choose the ones we want to close and the ones we don't want to close, and the terrorists sitting there watching us would get a mosaic, would get a roadmap to what we know and what we don't know at any given time. That's their argument, and they'll run that off the flagpole, and maybe judges will see there's something to that. But I going into detail on that to say that it's not, it's never been enough to just stamp national security on something and federal judges just salute. There's always a way of, you have to narrow the issue and really apply it in the context of a real controversy. Well,
of course, I can attempt at least to be less convoluted in the question, because it's very meaningful to me. I spent a lot of time being chairman of the film rating system, 20 years. That was my sentence. The Congress, as you've pointed out, has several times now attempted to pass legislation that would be protective, in its estimation, of our children, the courts have systematically gutted that. Do you think that if they were written better, if they didn't do all or nothing at all, that there would be a sentiment on the High Court now, as you observe it, to let some of this get by?
Yes, I do think so. They'd have to be written, a fair amount better, but you can read the court's decisions in this area as kind of a roadmap to what's troubling them. What troubles them are vague standards and prohibitions on speech that sweep so broadly that in the name of protecting children, it deprives adults or the adult internet community or the adult library using community or whatever of access to material that is constitutionally protected for adults. And that's been the flaw in these statutes. But actually the last one that the court looked at in this last term, it ended up with a very equivocal, splintered decision and sent the case back to the appeals court, one of these internet cases. And it's possible that as it comes back up, the court would say, okay, you fixed, we told you what the problem is and you fixed it. So, it's not all or nothing.
So you don't think that it's intransigence now, a court that just isn't going to move?
No. They're looking, these are 9 justices who don't agree on, all that much. They've all managed to kind of find some common ground in this First Amendment area by being quite nuanced and quite fact-specific. They're not just kind of out there sloganeering, and so there is room, I'm sure there's room for Congress to come back with a more narrowly tailored sort of approach.
And Roe v. Wade, what's its lifespan going to be in your estimation?
Forever, as far as I know. I think that's pretty
You do
settled
feel
law.
that way.
I do feel that way. Yeah. I put it this way: I have a hard time imagining a Supreme Court that would overturn Roe against Wade. And if that ever happened, I think the political system would take care of it and make abortion available nonetheless. Roe against Wade says there's a right to abortion. The opposite of Roe against Wade is not a prohibition against abortion. So I think the right to abortion, at least for those who can afford it, that's obviously another big question for those who have access.
Quite a right.
There will never be a time in this country when there's not availability of abortion. I'm quite sure of that.
For the rich or the poor or just the one?
Well, rich and poor. I said that because there are many counties in this country without abortion providers. It's difficult, especially for young women, people in rural areas, and so on. I don't want to minimize the burdens that states have managed to put up, but this is a country where I think the voters have spoken that access to abortion is pretty much taken for granted, and so the Supreme Court's certainly not going to be in a position of taking that away.
The Lord giveth, the Lord taketh back? No?
No, I don't think so.
Okay. I asked the question and I got your answer. Are there other flashpoints where you think fundamental changes, reverses may take place, could take place?
Well, of course, the voucher case, the Cleveland voucher case last term was a major step in authorizing, under the Constitution, states to make public money available to support tuition to religious schools. Now, the way the majority wrote that opinion, the Chief Justice made it, kind of grew it out of recent precedents, and this was obviously the trend on the court. If you read the majority, you won't find an acknowledgement of a sharp break with the past. It was nonetheless, if you just step back and look at the last 10 or 15 years, it was quite a break, because certainly back in the 80s that was not the case. This majority would not have prevailed. So to the extent that the role of religion in public life is a flashpoint, that's in play, definitely.
Any others?
Well, you know, one big debate in the country now, I think growing, is over capital punishment. And it was in 1976 that the court said capital punishment within certain framework is all right, does not violate the Constitution. Last term, the court said it does violate the Constitution for defendants who are mentally retarded. I think the court is kind of in a dialogue with the larger society on this question. In no way do I expect the court to go back to what it said in 1972 in the Furman decision and say capital punishment's unconstitutional. But I think some justices are troubled by the application of the death penalty in the country, particularly by the lack of access to decent defense lawyers that a lot of defendants seem to have. So I think the court is kind of watching the situation pretty carefully.
I read a speech that Justice Scalia gave, and I would say, of course, he doesn't fit into that category. He's pretty one-sided. He's made up his mind.
Well, I mean, you know, no matter what he thinks of it as a citizen or as a Roman Catholic, and it was an interesting speech, what he says there is that, in his opinion, any judge whose Catholicism, religious-based opposition to capital punishment would trump his obligation as a judge to interpret the Constitution ought to leave the bench. Some people thought that was a very controversial statement. To me, it seemed like garden variety civics. I mean, I thought he was simply saying, you know, I'm here not as a Catholic, but as a judge, and my job is to interpret the Constitution. And the way he interprets the Eighth Amendment's cruel and unusual punishment clause is, in his understanding of the intent of the framers, and capital punishment was part of the fabric then, and so obviously they didn't mean capital punishment when they raised the possibility that some punishments might be cruel and unusual under the Eighth Amendment, and that's his view.
And I was going to say we're stuck with it, but I wouldn't. That's passing judgment, which is not my business. But I was fascinated by the report here of the speech. Quote, "You want to have a fair death penalty," U.S. Supreme Court Justice Antonin Scalia asked an audience of nearly 500 academics and others. "You kill, you die. That's fair." It's that absolutism. Again,
well, he's his own worst enemy. I mean, he's being very flip there. I think it actually was quite a thoughtful and interesting speech. But that's Scalia. I mean, he goes for the kind of soundbite, but beneath that, he was dealing with an interesting issue. You know, what's a judge's proper stance in a kind of a moral universe where his loyalty, where there's two different calls on his loyalty. And Scalia was saying, you know, my loyalty, I took an oath to the Constitution. That's my loyalty as a judge, and, you know, this is my constitutional view.
Let me ask you one question covering an area that is so important. The Gore election, or miselection, or stolen election, whatever one's perspective can be. What did that do to the court? Did it do as much damage as I would have imagined?
Evidently not. You know, the surveys have indicated, surveys taken quite soon after the fact when the wounds were still raw in the country, that didn't change people's view of the court. People that didn't like the court still didn't like it. People that liked the court thought it was fine. There was not a diminution in the court's standing in the public eye. And within the court, I think, although wounds were obviously pretty raw there too, I think people made a very concerted effort to stay on track and get back to business, and they did. I don't think there's really a lingering issue there. You know, they don't have the luxury of kind of sulking in their tent when there's only 9 of them and you've got to be able to call on or hope you can get anybody's vote in the next case. It's not like Congress where, you know, there's 435 members of the House and the whole caucus can go off and sulk in the cloakroom somewhere. The court can't do that, so they got back to work.
Is that different from episodes of the past where there have been bitter conflicts that held on, that continued?
Well, there's a very bitter conflict now over these federalism cases that I think is more bitter than Bush against Gore was, in the sense that the dissenters in the federalism cases, Breyer, Souter, Ginsburg, and Stevens have said, you know, we just don't agree with this, and we're never going to agree with it, and we're going to keep dissenting, and we're going to keep dissenting. That's unusual. That bespeaks some real hard and deep feelings that are lingering on that whole side of the docket.
Souter, what role does he play in all of this?
He's a very thoughtful, careful judge, speaks with a lot of authority. You know, he's not what some people expected, although everything he is on the court, he flagged it all in his confirmation hearings, which were very fascinating, and he's a good old-fashioned Yankee Republican.
How do you explain his nomination?
Oh,
given what you just said.
No, that's easy. He was Warren Rudman's protege in the New Hampshire Attorney General's office. Rudman has always been crazy about him and had a goal to get him on the court someday. Got him on the First Circuit, and then when Justice Brennan retired suddenly in the middle of the summer, unexpectedly because he had a stroke, Senator Rudman got his buddy David Souter's name in play, and John Sununu, who knew certainly that Souter was a good deal more liberal than he was, couldn't say no because Sununu was the former governor of New Hampshire and Souter was a New Hampshire product, so that's what happened there.
Is it all happenstance? I mean, somebody has a stroke, someone else is in the seat of power?
Happenstance, fate. Yeah, absolutely, sure. You couldn't plot this out, that's for sure.
You can't plot out the Supreme Court of the United States.
No, and that's why people that say, you know, who's Bush going to name and who's going to retire and this and that and the other thing, who knows? It's all a product of the dynamic of the moment, and we can't forecast that.
Well, simple answer to that is come back in 6 months, 6 years, and we'll do another program. Okay. Thanks, Linda Greenhouse, so much for joining me today. Yes. And thanks, too, to you in the audience. I hope you join us again next time. And if you would like a transcript of today's program, please send $4 in check or money order to the Open Mind, P.O. Box 7977, FDR Station, New York, New York 10150. Meanwhile, as an old friend used to say, good night and good luck. Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Malkin Fund, the Commonwealth Fund, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, and from the corporate community, Mutual of America.